It's preparing to live stream, so that's why I'm not talking. Okay, it's February 9th. Welcome to the Banking, Consumer Protection, Commercial Law Subcommittee. We're going to take up HB 148, HB 218, and HB 84 in that order. Okay, HB 148 was Delegate Carey's bill. We actually addressed this last session, and I believe it was voted out of both committee and off the floor. Tiffany Clark, do you want to have any comments on HB 148?
Yes, I'm trying to share my screen here. Okay, can you all see this? Okay. 1 second, let me go to 148.
Tiffany, are you on mute?
Can you hear me?
Yep.
You can hear me?
Yes.
Okay. I'm sorry.
Yes.
You can see my screen.
Yep.
Okay. I think we're all together now. Okay. So HB 148, this is Delegate Carey's bill. This bill basically expands the Maryland Personal Information Protection Act to include genetic information in the definition of personal information. So genetic information is, things like saliva swabs and things like that for DNA tests and things like that. It also expands the types of businesses that are required to implement and maintain reasonable security procedures and practices to protect personal information. So previously, businesses that maintain this information was not required to reasonably protect it, just people who owned it or leased it were required to personally or reasonably protect it. It also shortens the period within which certain businesses have to provide required notifications to consumers if there is a data breach. So previously, a business had 45 days after the conclusion of a investigation to notify a consumer of the breach. They are taking that part out now and saying that they have 45 days from when they become aware that a breach has happened. And it also adds some information that a business who has had a breach has to provide to the Office of the Attorney General. The Office of the Attorney General said that they would get these notices and really didn't have anywhere to go with it because they didn't really exactly know what happened with the breach. So this is giving them more information to do their job. And it also finally, this bill does a lot. It also alters the manner in which substitute notice can be given for this breach. So beforehand, we were saying that substitute notice could be given if it was a business found it costly to notify people directly. So that part has been taken out and clarifying that substitute notice can only be given if a business doesn't have sufficient contact information to notify a person of a breach. This bill has one amendment and it's from Delegate Carey and it is a clarifying amendment. That's essentially the bill.
Okay, so I guess do we need to vote on this amendment?
Yes.
Okay.
Madam Chair.
Yes, sir. Delegate Adams.
Thank you. So the bill that we're looking at here, are you saying, did you go through the amendment or was this the bill itself, Council?
That's the bill and the amendment is a clarifying amendment. So the way that the substitute notice, let me see if you can see this. The way that the substitute notice part was written is incorrect. So it's just, it's clarifying, it's making it correct. It's not a substantive amendment.
Does the bill, and I'm reading some testimony here, Is it still the 10-day requirement? Is that in the bill?
Yes, hold on one second. We're going to find this. So this is, I believe, what you're talking about right here on the bottom, on the top of page 5. So a business that maintains computerized data that includes personal information has 10 days after discovering that there is a breach.
And I'm trying to remember the testimony in the hearing, but what was the reason for changing it from 10 to 45? I'm sorry, from 40.
From 45 to 10. Basically that by the time that people were notified that there was an issue, it was too late to do anything. So, by the time people knew that they could, that there was an issue, they couldn't change any passwords or anything like that because it was just too late. So that's the theory in moving it the shorter period so that people actually know, so that, they have time to make changes and protect themselves.
So it seems like to me, I'm reading some opposition testimony that the time frame of 10 days is arbitrary and probably not enough time because they're still trying to determine the scope of the breach and they want to avoid multiple disclosures. So throwing a disclosure out in 10 days may not be the actual description of what the breach actually is. It doesn't give the businesses enough time to actually go through and do a fairly decent job of figuring out what happened and then notifying the the customer. And so that I guess I'm curious.
I think Delegate Adams, I believe those were the same sort of discussions we had last session. I mean, that was the compromise we came up with that we passed out last session, if I recall. So that's not a change from what we did last session. Those arguments were still made then, and we, decided this was the best approach, is my understanding.
Well, how about that?
I'm sorry, Delegate, I remember that, and yes, we did pass that out last time. Delegate Adams, good to see you this morning.
Good to see you, Dinah.
Delegate Pippi has his hand raised. I'm sorry, go ahead. Delegate.
I didn't have the pleasure of working with you guys last year on this. I kind of thought, it seems to me that the biggest concern in the testimony for folks either like supporting an amendment or just opposition in general is the time frame. And one of the issues I know we have in Frederick and then in Maryland is with these mail delays. So I occasionally get a letter, with a data breach, and I'm just thinking, is there some validity to that concern now? And I don't know this bill like the back of my hand, but I would imagine most of these notices are in writing through the mail. Are they even able to get a notice out, with some of the issues we're having in the state with mail? Is that a concern that we should talk about? I'm not opposed to the bill in general. I feel like that 7 days would almost be impossible right now to do, but.
My feeling is that we sort of talked about that. Of course, we saw some issues with, mail with COVID that, I don't know how we address that. Are we gonna not do things timely because we have a problem with our U.S. mail system, or we fix our U.S. mail system? That that would be the answer. I certainly listen to others. Delegate Fennell has her hand raised, but my inclination is, because the only amendment is a clarifying amendment, we go with what we have here. But again, it's the will of the committee. Delegate Fennell.
Let me apologize, Madam Chair. I actually jumped in without raising my hand before, but I as stated in reference to, we did pass this out last year. And I do understand what you're saying, and Chris and Delegate in reference to the mail, but we need to move forward with this. And I think in reference to it's 7 days, it gives them, was the 7 days, correct? It's still the same thing in reference to 7 days. So I think that, I think we just should move on it. And that's Madam Chair.
Okay. Delegate Adams has his hands raised.
Thank you. And let me just give you the counter. You're saying it moved out. This bill didn't pass out of Economic Matters last year. It may have passed out of subcommittee, but this is not a bill that got vetted on the House floor. And I think that the nature of the time, I mean, we're just talking, there are multiple issues with the bill, but the timing, if we're going to make the bill workable, then let's make it workable. 10 days does not allow enough time to have a thorough discussion about what the breach is and then give the consumer a responsible answer by way of mail. So this is not necessarily an amendment trying to hurt the bill. It's trying to make it workable and practical.
So Delegate Adams, what are you suggesting then as a time frame?
I keep raising my hand, lower my hand. If I were here last year and we were in person, one of the things I may have asked to do is to hear what the opponents of the bill were saying. I mean, I'm trying to read off of testimony, and I'm trying to recall, and I don't necessarily recall this bill from last year, obvious reasons. But I mean, if we're going to move a bill that's this thorough, my concern is first and foremost, yes, I want to make the bill workable. So we're talking about the time frame. I started that, that question. I would want it to go back to, the 45 days, because you can still have the other definitional changes that you want in the bill. But, I'm a big fan, Chair, of having bills that can actually be put in practice and make them workable. So whether or not I agree with the principle of the bill, I do think we need to give the businesses the ability to be able to apply the law without getting hung up in some legal trap because they didn't meet the time requirement in this case. So thank you.
Understood. I believe that, but 10 and 45 days are a big difference. So that's why I was asking for a suggestion. But okay, we can look at that as well. Delegate Crosby.
Thank you, Madam Chair. Thank you, Madam Chair. I just went back and kind of pulled up the hearing on the website and just listened. It seemed like that all parties agreed to the 7 days. While some may not have loved it, what they worked off of last year, they agreed to that time frame. And although it's apples to oranges, the EU has a 72-hour requirement, and then states like Florida and Ohio have a 10-day requirement. That came directly from the brief. So it seems like they kind of hashed this out already before the hearing.
Yeah, that was my understanding too. Delegate Jackson.
Thanks, Madam Chair. It would seem to me like 45 days is too long. I think in instances like this, we need to do everything we can to make sure that we're getting that information to the consumer so that they can, take the appropriate next steps to protect themselves. If what is it, 7 days, as it's currently written, is too short of a time. 45 days is definitely too long, as far as I'm concerned.
Okay, thank you. Delegate Fennell, your hand's raised again, or is it up from last time?
Madam Chair, yes, it was raised again, and Delegate Adams in reference to, yes, and you're absolutely correct in reference to passing out the subcommittee. It did pass out the subcommittee, and then in reference to the ECM as of yet, but as Delegate Jackson stated, it's 45 days will be too long. It is too long. And Delegate Crosby stated right in reference to the 7 days. We did do it in the 7 days. So in reference to what Madam Chair stated, the difference between 7 and 10 days, I mean, it's just 45 days is just too long.
Okay,
That's all I have to say.
Okay, thank you. I see Delegate Crosby. Is this again, or is this a new?
No, I'm quite possibly the worst with my hand. Sorry.
Okay, so Delegate Pippy.
It's one of those things where if move out of the subcommittee and the votes are already there, but there's an opportunity to move the needle to 21 days. I mean, I'd be remiss if I didn't at least try that. I don't know what Delegate Adams would think about that, but I I mean, it's halfway there. You know, you could make the argument that you're cutting the time frame in half to keep people better informed. And it also seems more reasonable to actually give an entity, you know, the opportunity to get a notice out in a realistic time frame. So if anyone has a comment on that, I mean, the suggestion's there, 21 days. It's half the time frame they had before, but.
Okay, I'll listen to, I think I have Delegate Adams again, and then we'll move forward on that suggestion. Delegate Adams, is that a hand raise again?
Yeah, I was just going to say, Madam Chair, that any concern that I have, and if you remember in past years when we have hearings like this, I'm usually in a spot where I can ask the proponents, and I'm reluctant to negotiate on behalf of people as we're trying to develop consensus here. And while it may not come across like that, I'm a layman, so I'm not necessarily an expert in any of this. We're trying to advocate for a business position, and it would be valuable if we're going to start throwing numbers or days out and try to negotiate that. I don't think I'm in the best spot to have that conversation. But if it's the will of the committee to move the bill today, then I assume that more time is better than less time, and the testimony I'm reading. So the only thing I can base this off is what I'm reading from the hearing, and just say that the 10 days is not enough. And I would just encourage the subcommittee to, as we're doing this, try to incorporate the people that are involved in these bills and their lives.
Understood, Delegate Adams, and the reason
that'd be my last word on this, and I do appreciate it. You give me the
and the reason we did not have only the sponsors here, because these were bills, as I alluded to, we had dealt with before at the subcommittee level. I thought we had gotten this one out. It's the other one that we got out that I'm thinking of, that we did get out of committee. So I wasn't expecting this level of conversation, because we had dealt with many of these issues, and the only amendment that I was aware of was a clarifying amendment. But going forward, we will make sure that folks are available to do that. So what I would propose, and unless we have some issues with that, is that we can entertain the 21 days on a committee vote here, subcommittee vote here. But if we move the bill as it is, we will have time to address it at the full committee. Would that work for people?
I like that approach.
Okay. So since Delegate Pippi did propose an amendment of 21 days, we do want to take that into consideration. All in favor of that? Can we just do a voice vote of aye?
Aye.
Aye.
Okay. Oppose?
Oh,
Aye.
Aye.
All right.
So I don't think, so the 21 days does not pass. The bill has an amendment, a clarifying amendment on it now. Is there any opposition to the clarifying amendment?
Move approval of the amendment.
Second.
I beat you,
All in
Diane.
All in favor?
Aye.
Any opposed? Okay, so we will move this bill as amended. Can I get a motion for that? Move the bill as amended?
So
Favorable?
moved. Yes.
Do I need a second on that? I don't know. Council?
I can't second. Did somebody second it?
Did somebody second? I'm trying, do we?
second.
Okay,
I didn't
thank
hear
you.
it.
Can we have a brief discussion on this bill, Madam Chair?
Oh,
Was there any opposition on this bill beyond the time requirement, or were the opponents generally weren't concerned about the time frame?
It was the time requirements.
So provided we've resolved the time requirement, the bill would have support.
Mhm.
Okay.
There was a small issue about the definition of genetic information.
that's
But
good.
my understanding, the reason why that definition of genetic information was used is because it aligns with the federal definition of genetic information. So
Delegate Rogers, is that a hand?
Yes, Madam Chair. So my question is, I mean, are we gonna go back to the sponsor and inform the sponsor that we arbitrarily changed the time requirements from 7 days or 10 days to 21 days?
We haven't changed it from what the bill has come in. What
Okay, got it.
to is we'll pass it out of committee. And if there's some major concern, we can take it as up at the full committee, is what I'm saying. The subcommittee will pass it out and then it'll go to the full committee.
Thank you, Madam Chair.
Issues around that weren't resolved last session, which we believe were, but we're going to give people that time to answer that. It'll be addressed at the full committee. Is that okay?
Yes, ma'am. Thank you,
Okay.
Madam Chair.
Sorry about that. Did your question get answered, Delegate Adams?
Yes. I mean, I think so, but yes, you're good. This Zoom world is not easy, and I know that this, and I appreciate what you're trying to do, and I thank you.
No problem. So I think we're at the point of moving this bill as amended favorably. Any objections to that? I'll just do it this way versus, council, do we need to have the individual votes or we need to call people?
I would prefer to do that. I can call
Okay,
them
that's
out.
fine. Let's do that. Sorry.
Okay. Delegate Adams,
You're only first by alphabet.
No, that's fine. You can do it from here on out. I'm just, I got caught off guard. There was no opposition to the bill other than time frame. We feel like we resolved that as subcommittee.
I
and that
think at the
little
subcommittee level, we
repetition.
have resolved that. We can address anything. I think if you want to, we want to have business folks to come in at the full committee, we can take it up as an amendment at the full committee. But I think, my understanding, we have resolved that issue at the subcommittee level. We voted.
Okay, Madam Chair, I'm going to support the bill on subcommittee
Okay, thank you.
as amended. I think if we've resolved the issues, and I'm okay. Thank you.
Okay, thank you. Go ahead. Next.
Okay, Delegate Crosby,
Aye.
Delegate Fennell,
Aye.
Delegate Howard. No, okay. Delegate Jackson,
Aye.
Delegate Pippy,
I'm going to vote nay, but only because of the time frame issue. Otherwise, I'd support the bill. Thank you.
Delegate Rogers,
Yes.
Delegate Watson.
Aye.
That's it.
Okay, thank you. All right, so we will move that forward. And then again, any issues we'll deal with at the full committee. Next bill, HB 218. Again, this is a bill that we did pass out of subcommittee. We did pass out of committee and off the floor. The bill came in this session with a change that made it more in line with what the Senate wanted. And so in my understanding, that was to make it less onerous, to address some of the concerns that have been raised about some of the lawsuits kind of related to this bill. But so this is again a bill that did have a lot of conversation at our hearing this year. So I kind of open to figure out what some of the concerns are. I'm not sure if all the concerns were based on this year's version of the bill or prior year's version of the bill, but I'll let the council talk through this bill and we can deal with this one as well.
Okay, so House Bill 218 requires any private entity in possession of a biometric identifier or biometric information to develop a publicly available written policy establishing a retention schedule and guidelines for permanently destroying that information. The bill also requires the private entity to store, transmit, and protect from disclosure biometric information and biometric identifiers. The bill prohibits the private entity from selling, leasing, or trading the biometric identifiers or information. The bill prohibits the disclosure of biometric information or identifiers unless consent is given by the consumer. And finally, the bill authorizes an aggrieved consumer to bring a civil action against a private entity that violates the requirements of this bill. There is one amendment from Delegate Love, and it says that if a private entity wants to disclose the information, they have to get the consent from the consumer for each individual disclosure. So before it said the disclosure, the amendment is saying that for each individual disclosure, consent must be obtained by the consumer. And that is essentially what the bill does.
Oh, I guess I should raise.
Okay, Delegate Jackson, is that a hand or?
Yeah, I'm sorry. I was trying to hurry up. And so, Council, is that the amendment that you just received?
No. Would you like to?
Oh.
I can't pull it. I didn't have time to pull it up or put it into anything.
Okay. Well, I submitted as we passed out of committee last year. I submitted the language that would require that the company inform individuals or individuals of legally authorized representative in writing. Pretty much they let the consumer know what they're doing with their biometric information. That's how we passed the bill out of committee last year. I just honestly believe that people should know what's happening with their biometric identifying information.
Understood. So let me just ask a question. Was that part of the changes that were made to?
That's what was removed, yes.
So
I
the
believe that's the only thing that was
The
removed.
Senate took it out. Is what
Say that again.
I want to clarify, was that part of the changes that we passed out last year that the Senate took out? The in writing piece. So you want to
Yes.
put it back in to make
Well,
it.
at least bring it before the subcommittee to discuss.
Understood. Okay, I just want to make sure I'm clarifying what, okay, got you. Anything else on this? Delegate Fennell, that's not a hand, right? Delegate Adams, that's a hand.
Yes, it's a hand. Yes, it's a hand.
Oh,
Madam
sorry,
Chair.
Delegate Fennell first then. So,
Delegate Jackson, my Senator Augustine, took this up, cross-filed the bill. He was the one that actually made the change in reference to this bill. So I had talked to him about it, and I support this, the amendment that he did in reference to Delegate Love. So I just wanted to let you know that, okay?
Okay.
Okay.
Delegate Adams, that was a hand.
Yes, yeah, so just, I wanted to address the amendment because the way that I'm reading it, I think that it makes it even more difficult for this bill to be applicable. I don't know that and I'm trying to parse out what you're saying. Are you saying that the bill went across to the Senate and the Senate didn't act on the bill, or did they remove that part of the
My understanding is that the Senate never got a chance to act on the bill, and what they had in their version was different from ours, and it was less onerous. I don't think they voted it out last session, but it's a question I'm not sure of.
Okay.
Yeah, I'm not sure of. I understand that what they would have voted out if they voted out would have been the version that we're seeing this year.
we don't have we don't have the amendment in front of us, so I don't know that.
No, the amendment, the bill came in this year the way it was with the Senate. It didn't come in this year the way we voted it out. That's what I was saying.
Oh, I see. Got it.
Yeah. So the only amendments we have to the bill that came in this year is what the council talked about was the changing of the to each. And then what Delegate Jackson is referencing, which puts it back to the way we voted out, the House voted it out, but the Senate did not, was not in agreement with. Is that clarifying, Delegate
It
Adams?
is, because it sounds like there's some disagreement as to how this bill would look when it actually passes both houses. And so it sounds like we're trying to work this bill in a way that would pass the Senate or not.
Is-
I'm only talking about Delegate Jackson's amendment. I was trying to address, there are other things to talk about on the bill. I just was trying to make sure I understood, especially if we're
Well,
trying to move that
I
amendment.
guess, Madam Chair, ma'am. For a reason.
Okay, I'm sorry, Delegate Adams. I'm getting somebody else's meeting crossed into. Is anybody else hearing what I'm hearing, or am I missing something?
I can hear something.
It's
I don't
not
know
just
what-
you. I can hear it too.
I don't know what to do with that. I can't
I
get rid
hear
of
it
this. Do
too.
I have something else running that I don't know about?
I hear it.
Uh-oh. I think I lost everybody because I got rid of that. Oh, Lord.
I
Can
see.
you still see me? Okay.
Okay, and
I
hear
think, sorry about that. I had some other section running. Okay, sorry about that. So basically, I don't know, what are you saying, Delegate Adams? You don't think we're talk about this bill, or we don't want to deal with these amendments? I'm not quite sure what action you would want me to take from your statement.
Well, is Delegate Jackson proposing an amendment now, or is that not the case?
That's a good question. That's a good point. Does Delegate Jackson still want his amendment, knowing that it's different from what the Senate wants, I guess is a question. That's a good point.
Well, if that's what the Senate's want, I'll just withdraw the amendment.
Okay. Okay, so Delegate Jackson's amendment would be withdrawn. We would still have the amendment from the sponsor, which changes the to each. I don't know much about that. I don't know if that's making it in line, council, with what the Senate has, or if that's another change that may be different from the Senate. Do you know at all? Do we know?
No, I don't know what the Senate is doing about that, but I know the reason for the change is just because if they disclose this information multiple times, the means only one, each means every single one that they do it.
So to
it's-
identify multiple times, okay.
Yes.
Okay, so I think we do have to deal with that amendment as a subcommittee. And does anyone have any questions on the amendment? This is the amendment from the sponsor of the bill that changes the wording from the to each. Delegate Adams?
Well, because I've not thought about what that does to the bill, it sounds like it makes it more difficult to apply. So what was the reason? What was the reason for the sponsor wanting this amendment? What are they trying to address that they didn't address during the hearing?
So if somebody has an iris scan or something and they want to disclose it, the bill says that you have to disclose it for the disclosure, but each is making sure that every time it is disclosed, they have to notify the consumer. So the kind of makes it one time. Each makes sure that every single time it's disclosed, you're getting consent from the consumer that it's disclosed.
So you're getting consent if I did it on Monday and then turned it
Mhm.
again on Wednesday. Is that what you're saying?
Mhm.
Okay.
Wow.
Delegate Pip, oh, sorry.
Wow. That's
Okay. Delegate, Delegate Crosby, sorry.
I know me and Pippi look exactly alike.
No, isn't that, sorry.
No, we get it all the time. It's all good. Thank you, Madam Chair. So I think that this is the AG's amendment, and that is what they requested. I know the sponsor put it in, but I'm pretty sure this is what the Attorney General is asking for.
Thank you. Thanks for that clarifying information. Delegate Mouse.
Yeah, thanks, Madam Chair. I in the last roll call on that bill, my name wasn't called. And so I logged off to make sure like chairman hadn't taken me off the subcommittee. And then I came back and I don't even know what bill we're doing right now. I'm having a really hard time with this. Really hard.
I'm sorry. Well, I think we had a question, were you still in the subcommittee or not? So that's a good point.
Okay.
Am I or am I not?
I don't know. Let me check that real quickly. But we're on HB 218. This is Delegates Love's bill, which we talked about last session. So sorry about that. Was that the only question you had right now, Delegate Mouse, or is it questions
Yeah.
more about
I just need to know what bill we're talking about. I don't.
HB 218?
All right, thank you.
Okay, so I think at this point, unless I have other questions, we should deal with the sponsor's amendment of the to each. And
A motion
vote it
to
out of committee or not, whatever.
make a motion to deal with the amendment, amendment. Yay.
Okay,
Second.
okay, thank you. So we have that to be, we're going to deal with that amendment. So if those in favor of the sponsor's amendment changing the to each, would you say yay or yay? Those in favor?
Yay.
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 Those opposed?
Nay, or yes for the opposition.
Gotcha. I got 2, 3. Okay.
I'm opposed to that.
3 people so far, Pippi, Adams, and Mouse. Anyone else opposed? All right, so that gives us, so that does move it towards, and again, the understanding that that is an amendment that was brought by the sponsor from the Office of Attorney General in favor of moving the bill out of subcommittee with that amendment. All in favor? Motion for move favorably with amended?
Discussion?
Oh, sorry, I'm missing Delegate Adams, sorry.
So the bill creates this private right of action. And I would be completely opposed to the idea that we allow aggressive plaintiff attorneys the ability to approach this. The point I was trying to make during the hearing was this idea that we have the Attorney General who has jurisdiction under law with relationship to consumer protection, and that they certainly, the Attorney General has the ability to apply criminal penalties. And I get the response, and I'm reading the letter that sent that this private right of action is for civil consumer relief, financial relief, and not necessarily for criminal penalties. But the point remains that we should be reserving violations of any law like this to, first off, an elected official in the state of Maryland who's accountable to the voters, and that is our Attorney General, and that we take very seriously the obligations under the Consumer Protection Act. Allowing broad sweeps to plaintiff attorneys to just shoot lawsuits around on this is at best is going to be difficult, but at worst, and it will be worse, it's creating such an onerous obligation on employers, and if we're trying to pass a bill, a rationale that we're trying to create obligations and add to what's already there, that's one thing. I would believe that the subcommittee should seriously consider how unique this sort of expansion of prosecution would be. And on its face, again, even if I agreed with this bill, I could never possibly justify having private attorneys, going around looking for reasons to sue companies over something like this. So my appeal to the subcommittee is to, yes, let's look at the policy, whether it's good, bad, or indifferent, but no, let's not open the door to Pandora's box with relationship to lawsuits. And I would surely, if the intention is to move the bill out, I would want to fashion some amendment that would strike the provisions of the private right of action.
Okay, and any other comment that I think, if I recall, I thought that was part of the issue that was dealt with. They changed the bill to make it more in line with the Senate. And maybe I'm wrong with that, but maybe the council could provide more details. But I believe Delegate Adams, those concerns were addressed with the revision to the bill as it came in this year as compared to what we did this year. But I may be wrong with that. Any council, can you provide any guidance on that?
My initial reaction is to say, I think that that was already still in the bill last
Oh,
year,
okay.
but I can go ahead and check if you want me to.
It's still in the bill last year. Or
It
it's
was in the bill last year, I believe, but I can go ahead and check.
It was still in the bill last year that we passed out, is what you're saying,
Mhm.
those concerns
believe.
last year?
I believe so, but I would like.
And
to
it's
go
still in
ahead
the bill this year?
Yes. The
Okay.
only thing I believe that changed was the consent language, well, the first consent language.
Okay. So fundamentally, those issues that Delegate Adams had weren't addressed last year and have not been addressed for this year. Is that's a valid statement?
I believe so. Hold on one second. I'm just trying to, I don't want to tell you something incorrect.
No problem. I don't want to ignore your comments, Delegate Adams. What's the difference as to whether we have dealt with this before or, is this a new issue? Is that making sense? My clarification?
Right. So this was a bill that came up last year, and I do remember it from last year, unlike the prior one. And the fact that we were in a shortened session has me believing that there were issues like this that perhaps weren't vetted. And I'm also, because I know this is an important issue, I know that there was other vehicles for this type of legislation that were showing up in different bills that were coming forward. And of course, Chair, I think that those conversations are so hard to recall on demand here. And I get the impression, and if it's the will of the committee to move the bill forward, I don't know if you would give me the pleasure of holding this bill so I could literally try to understand what's happened between the Senate and the House. And also, if we're going to have this conversation, I need to remember what bill was happening last year that had this subject matter attached to it, because I believe that they were working a different bill related to this. And I think it's worth, for the sake of this conversation, if we're going to move the bill out of our subcommittee, that at least, and I'm hopeful that we have others that are interested in the topic, but hold it long enough for us to look at this, because this private right of action is a big deal, and it's also a big bill. I mean, this is one that I think requires work if we're going to move it, and we know that because if it's true that there was another bill, not this sponsor's bill, but another larger bill that was coming through in the Senate that had this subject matter in it, that there may have been some negotiations, and I think we should make sure we're incorporating that in this conversation.
Okay, understood. Delegate Crosby?
Thank you, Madam Chair. Just to follow up on that point, the Senate hasn't done anything with their version yet, so they haven't moved. So there's no difference between this bill and the Senate bill at the moment.
Okay,
Delegate, can I
sure. Council.
intercede here? So last year, the private right to action was actually in the bill. So the only thing, like I said, the only thing that's different between the bill that you all passed out last year and this bill here is that the language that Delegate Jackson suggested, that is removed from this bill. That is the only thing that's different.
Okay, thank you. So Delegate Adams, I understand it's up to the subcommittee, I believe, is the place where we're supposed to vet issues and make sure we come to an agreement. That's certainly the purpose of this subcommittee. My concern is that are we rehashing things we dealt with before? Because I don't recall, I thought last session we had a lot of bills that we vetted and went through, and I don't believe we rushed things because of COVID. We didn't, when this bill passed, I don't think we even knew about the impact of COVID. So it wasn't, to my understanding, a bill that we did not take time to talk about. I have no problem with, though, if we want to make sure we are in line with what the Senate is looking at or looking at this bill holistically. I just have concerns about rehashing things that maybe we dealt with before. But again, it's the will of the committee on what we want to do. If we think, what does the committee want to do? We want to hold it for a session and or hold it and talk to the Senate and make sure we get something that's more consistent across. I'm open for whatever the
Madam
committee
Chair.
wants to do. Yes,
If-
Delegate
if we're gonna-
Watson.
If we're gonna hold it, I don't really have an objection to that, but I do think we need to be clear on why we're holding it and what we are trying to accomplish or find out. So, Delegate Motz, I think you need to be as specific as possible.
And
Delegate Fennell, thank you. Delegate Fennell?
Madam Chair, and it is my wish not to hold this bill. And I agree with Delegate Watson. We hashed this out. I'm not clear why we will be holding this bill, and I do not want to hold this bill.
Any other comments? Delegate Crosby?
Yeah, thank you, Madam Chair. I would tend to agree with Delegate Fennell is that we kind of went through this last year. You stand the principle of the bill. We hashed out some of the issues in last year's subcommittee, and the sponsor came back and pretty much brought us the same bill that we worked out last year, along with making slight changes to make it a little bit more favorable. And so, given the fact that we've already done this once and there's no difference between the current posture of this bill and the Senate bill, I don't really know what there is to talk about with the Senate. If they pass a bill and there's some difference, isn't there a committee that goes to work them out after both bills pass and there's a difference? So wouldn't that be the appropriate time to address that?
Yes, there's a conference committee, correct. Delegate Adams?
Okay, so to address Delegate Watson's point and what would be the reason for asking that bill be held is that and I've been in the committee for 7 years now, every subcommittee, especially on difficult subject matter, includes proponents and opponents who show up at the subcommittee, have a discussion, whether we agree or disagree on what the opponents or proponents are saying. At least we're walking into a bill hearing, or at least a subcommittee hearing, fully vetting the issues and making sure that we're making good decisions. It's frankly one of the few tools I have at my disposal, because I'm not an expert on any of this. I'm knowledgeable, and I think we are all knowledgeable about many issues, but we're amending the Maryland Consumer Protection Act. This should not be a process that we take lightly, and I'm not saying that we are in this case, but I also am saying that every time that we've had a subcommittee, it's open to folks to come in. We are working amongst ourselves, and that's not helping at the very minimum. Even if I oppose the bill, it's not helping us deliver a good product. And I believe that my purpose, if you want my true answer on this, my purpose is to hold the bill so we can incorporate at least some conversations with those that support and oppose, so we can make good decisions. Right now, like we just passed an amendment, and I'm like, well, or maybe we didn't pass an amendment. The point is that we're, Madam Chair, under the world we're living in Zoom, I understand that there's some limitations, and So I surely am going to defer to your better judgment on this, but that's,
Sure.
this is not
Yeah.
an easy bill. Okay.
Yeah, no, I appreciate your comments and I agree. And as I alluded to before, again, the reason why we didn't, even though we're in Zoom, and as you mentioned before, if we were face to face, we would have the sponsors and advocates, those for and against, to be there with us. The reason we didn't do that on this call is because these bills, as our colleagues have mentioned, we did that with this bill. This bill went through the vetting process of the subcommittee. This particular bill went through the vetting process of our entire ECM committee. And this particular bill did even get off the floor. So this is not a case where we didn't hear the arguments for and against. And that's one of the reasons why I was asking what was the concerns. We dealt with the private right of action last time. We dealt with those concerns. And so to intimate that we aren't giving people a time to do that on this bill, I would take a little exception to that because we did that before. And going forward with other bills that we will hear, even in the Zoom content, we will make sure others are invited in to provide that the for and against sort of viewpoint, especially for those we haven't vetted. But these bills, as I alluded to, and this one specifically, went through that process last session. So that's why I just had that. But I wanted to open that up to the committee, but this bill basically went through that process of vetting that. So that's my only concern about this particular one. We basically, it's almost like we're rehashing a whole session that we had, even though it was cut short. We did meaningful work before it was cut short, and it's almost like we're negating that meaningful work. That's my impression of it. That's my thought. Is that okay? Or at least understood. It might be okay. Delegate Mouse, you have your hand raised.
Yeah, and kind of along the lines of the discussion is, this is not, we're not working on an issue that has got a great foundation. I mean, we're kind of on the edge of something new, and we're talking about some things that are not totally new, but they're not. It's not like I don't know, some of those things we debate and discuss and change for years on end. And that private right of action, how do we address that last year? Because I know I probably, if that were in the bill, I know I would have voted against it. Maybe I missed it.
You probably did.
Yeah, I probably did. I mean,
You probably did.
and so I mean that's a problem because I think Delegate Adams is overstating what happens to that once it becomes an issue in a larger forum. I mean, that's gonna drive votes away from the bill. But so I guess the question I wanted to ask is how did we resolve that? You said we addressed the private right of action last year. I don't recollect that discussion.
Hey, yeah, it looks like we haven't even got the felt marks.
Okay, no problem.
So we're gonna.
Yeah.
Delegate Jackson, you might want to go on mute. So Delegate Mouse, I understand your perspective, and I agree. This is a big issue. You may not have voted. I don't have the vote up now. You probably didn't vote for it last year if that was a concern, because as the council said, private right of action was in the bill last year, which we passed out. And so that wasn't a change. My inclination is that we deal with the bill at the subcommittee level because from my perspective, we have basically the same body here except for Delegate Pippi. And so that may change the outcome from the subcommittee. And if it becomes something that we need to look at, that either the Senate changes it on their bill or we change it at subcommittee, at full committee, we deal with it then. But you're talking about something that's germane to this bill that was here last year, and to suggest that we would change it now, I'm not quite sure I understand why that would be the case. If that
What was our subcommittee vote last year?
That would be, is that something we can look up real quickly for us, council, on the bill for this bill?
I don't have that because I was not here last year and we didn't.
I don't
have
know
those
that I
files.
can pull that up here now. But I do know this bill did pass subcommittee as well as committee and off the floor.
Okay.
That
Thank
part I do remember. But at this point, I would go with us voting or doing what we're going to do with this bill. It looks like as we may not get to HB 84, which is unfortunate, but we need to probably address this 218.
Madam Chair,
Yes.
I move that we move this bill out, favorably out.
Second,
Okay. So it's been moved and second that we move HB 218 favorably. All roll call.
Okay, Delegate Adams,
No.
Delegate Crosby,
Aye.
Delegate Fennell,
Aye.
Delegate Jackson,
Aye.
Delegate Mouts,
No.
Delegate Rogers,
Yes.
Delegate Watson,
yes.
and Delegate Pippy.
No.
Okay, 1, 2, 3, 4, 5. That's 5, 4, and 3 no.
Thank you.
Mhm.
All right, so HB 84, we are getting to a point where I don't want to take much more of your time, but I think this is one that's going to cause a conversation. So maybe let's hear some of the amendments and then we'll take this up probably. I'm assuming we probably will not have enough time to discuss this one voting, but HB 84, can we talk through the amendments, this bill and its amendments? And let's at least get through that point.
Sure. Okay, so HB 84 requires a person to make available to an independent repair provider or the owner of a digital electronic equipment any documentation, parts, tools, or updates to information or embedded software, or if it applies to equipment that contains a security-related function, any documentation, tools, parts, or updates needed to reset the lock or function when disabled. This bill applies prospectively. So basically anything before the enactment of the bill does not count. Anything after counts. So we have a couple of amendments here. Hold on 1 second. Let's see if we can pull this up. So the first amendment is from Delegate Queen. And this amendment says, basically provides that the bill may not be construed to require an original equipment manufacturer to divulge proprietary information for digital electronic equipment, embedded software, and firmware under patent or license exclusivity. Delegate Queen, do you want me to talk about this one and then go to Delegate Feldmarks, or how do you want to handle that?
Go to Delegate Feldmarks and then come back and explain how that impacts it totally, if that's okay.
Okay. And then here, can you all see that? Yes. We have Delegate Feldmark's amendment. Basically, there is a section in this bill that says, except as necessary to comply with the terms of this subtitle, require a, what are they called? Original equipment manufacturer to divulge trade secrets. So the except is necessary to comply with is stricken. And then she also adds here, so they are not required to, they can't be required to require an original equipment manufacturer to provide any information or tools that will alter the settings on motorized agricultural equipment in a manner that results in the equipment being out of compliance with any safety or emission standards. Can't require an original equipment manufacturer to provide access to the source code or any proprietary embedded software or code, or can't require, or it's not meant to require someone to grant to the leasee of leased equipment any right that is otherwise restricted under the terms of the lease. So together, reading these two amendments, I'm not exactly sure if Delegate Queen, your amendment would be necessary. It kind of seems like it's covered under this one, but I would, if you guys want to discuss that, that's fine.
So I have no, my approach, I hadn't seen this amendment yet. And so my was to address what could be some of the concerns that I heard raised. I take this bill as one of these bills that we're going to have to deal with at some point or another. It's something that's not going to go away. We can push the can, down the road, but this concept of how long can things be considered trade secrets or proprietary information, and how long does an individual have to be able to repair equipment that they own? What's the balance there? So I just think we need to get to a solution. How we get to it is what this committee can try to address. So I am up for discussion on what you want to do with the amendments, or again, I believe this is probably one that we will not be able to vote out today, but I would like to start to hear the conversations, if that makes sense. Delegate for now.
Madam Chair, I heard the council said that your amendment language is already in the bill. So.
I have no problem taking my amendment away. Yes.
Okay, great. That's it. Thank you.
Yeah. Any Delegate Crosby?
Thank you, Madam Chair. I guess this might be for council, or maybe this is just something we stew over, but I am curious how this does interact with federal law and the copyright provisions in the federal law. I don't know if this conflicts with it. And maybe that's something that, obviously we're going to bring this back next subcommittee session. So maybe we can, I'll try to do some research on my end, but we can all kind of think about how it interacts with that. Because I'm not 100% sure.
Yeah, so looking at the testimony, I'm not exactly sure that anybody is sure. I know that's a weird answer to give, but the Attorney General's office states there is no conflict. There's no issue surrounding that. But then there are other people who do believe that there is. So I think it's just a matter of you all reading the testimony and deciding, making that decision.
Yep.
Yeah,
I
have that same question too. And so I do. I think when I raised even my amendment, I didn't know would it be allowed at state level. So so some clarity on that, and maybe I guess the Attorney General would be the authority on that. But that is a question I think we need to answer. Delegate Fennell.
Apologize. I need to lower my hand.
No problem. Delegate Mouse. You're on mute, I believe.
Sure. The federal issues, I think the appropriate authority on that would be the federal representatives, not the state attorney general's office. So there's contacts there where I'm sure we can get an opinion from them to comment.
Okay, sounds good. Any other questions?
Madam Chair,
Yes, Delegate Watson.
can anyone recall from the testimony regarding other states? What other states? Any other states? I think I recall there not being any other states that actually had it passed, but there were some that were working on it. Is that correct?
Correct. That's what I recall. No state has actually passed it. There have been multiple attempts in multiple different jurisdictions to do the same thing.
Okay, and so we don't, therefore we don't have a model that's actually in practice right now.
Correct. The closest thing people were able to liken this to was about cars and
Right.
things like that. But there's no general model for repairing of digital equipment.
Okay. Delegate, the sponsor is here and she's been here all morning. So if she has any comments you'd like us to hear and to consider, I would give you that option right now. Delegate Philmar.
Well, thank you, Madam Chair, and thank you for the opportunity to be here. I really just wanted to be here to answer any questions about the amendment or, if I can be helpful, but it sounds like we'll be coming back to this. So certainly if there are specific questions that I can help with research on in the meantime, I'm happy to.
Thank you. Delegate Rogers.
Thank you, Madam Chair. Delegate Philmar, my question is, and just from my perspective, it seems to be pretty broad. I mean, and sort of all encompassing. Has there been any thoughts given to perhaps maybe tailoring it a little bit more? Because I know, comparing, piece parts components to say an automobile versus, computer programmers or gaming, or it just seems like there are different dynamics that are in play depending upon the specific industry. And so that's why I was wondering if there any thought had been given to maybe potentially tailoring this a little bit more.
Yeah, I think that, the bill as drafted is broad, and it's really based on sort of the fundamental principle of right to repair applying to all different types of products. But certainly if the committee feels more comfortable scaling that back to a certain type of product, I think, that might be the best approach to start if the full broad bill is sort of too unwieldy. I'm certainly open to that. I think getting that for a certain family of products would be a step in the right direction. So I would be, I'm certainly open to that, and happy to work with you on whatever direction or category of product or equipment you'd like to sort of focus on first.
Okay. So I'm not going to keep you guys much longer because I want to respect your time. I think we do have some good information about HB 84, at least some questions to get answers from. I would like to understand the federal law piece of it as well. What issues maybe other states, what were the issues that made other states not pass it? And so if we can deal with that, and certainly looking at the different industries and how it would be different could be a good step towards dealing with a problem I think we're going to have to deal with at some point. Any other comments people have? Okay, well, I appreciate your time. Thank you. And we will make sure we do a better job of getting more people involved. We did hear you, Delegate Adams, and we will make sure for future meetings have all the folks who need to be available. Any other things? Was that a hand for me, Delegate Adams, or you just, is that it? Okay. Thank you all for your time. Thank you, Council, and have a great day. Bye-bye.
You guys.
Okay, Madam Chair, thank you.